Okay, the system is on. Hopefully they can hear me. We do have a perfection, I guess it's from yesterday. This is Xavier Feldman. Do we have Xavier Feldman?
Is that the perfection, Your Honor?
Yes, it is. I'm just wondering if, can they,
I gave you the perfection, Your Honor.
right. Can they hear me at the main jail? Yes, great.
But they can't do it.
Can't hear you. Am I doing something wrong? I have system on and main jail hit. How's that? That's
I
better.
can hear.
Okay, that's better. Do we have the public defender there?
Yes,
Okay, what about Xavier Feldman? Is he at the main jail?
he's coming in, Your Honor.
Okay, so we'll put him on recall. What about Alvanico White? Probably at Paul Ryan? No, North Broward? Conte? She wouldn't be a Conte. All right, gang, am I doing something wrong here? Does anybody have Alvanico White? Good morning, sir.
Good morning, Judge.
And
Mr. Phelps here.
what is your name?
Corey Hill, Public Defender.
Okay, Mr. Hill, do you have Alvanico White there?
No, we do not. North Broward.
Morning, Your Honor.
Good morning, sir. Ms. White, you are being held on one count of criminal mischief. It looks like it's a felony, and you're being held no bond pursuant to a capias from Judge Susan Alspector. Okay, hold on just for a minute. Let me turn this down a little bit. Okay, go ahead. Can you make a $500 bond, ma'am?
I'm working on it now with my little sister. She has my debit card, and once I get in contact with her, I probably could.
Okay, so we'll set the bond at $500. Thank you, ma'am.
Sir,
Yes, ma'am.
is it a way I could have bond reduction?
This is count 3. She has count 1 and 2.
This is count 3, ma'am. You already have two other counts with a
Yes,
bond?
Judge. She has a total bond of $4,500 on those other 2 counts.
Okay. All right, thank you, ma'am.
Okay, thank you.
All right, I'll call your sister.
Norma McFadden?
Steve Planford, if the court will appoint counsel for her.
Oh, okay, is this a?
She wants to resolve, actually.
And where is she? Does anybody?
Maine, page 2, Maine, Your Honor. There she is.
Good morning, how are you? Ms. McFadden, you're charged with possession of drug paraphernalia. It's a municipal ordinance case. Your bond is presently set at $100. And it looks like you have a status set in front of the judge on 10/21. Can you make that bond? We can't hear anything from Maine.
Turn on the,
Is
turn
that
on the
my
mic.
problem?
Corey will do it.
There you go.
I was hoping to get that resolved today. She said I could get that resolved today.
Do you swear to tell the truth?
Yes, sir, I will.
And it's my understanding you wish to resolve your case today, waive your right to an
Yes, sir.
attorney and trust?
Yes, sir.
Are you
Yes.
are you pleading no contest to the charge?
Yes, I am, sir.
The court's going to accept your plea, find that it's freely and voluntarily given. The court is going to adjudicate you guilty.
I can't hear.
To talk to him, you have to be seated.
What can I do about that noise? Is there?
I can't hear her.
The deputy can turn the You can mute him.
Do you know which one I do?
The jail can do it. They can mute it.
Okay, excellent. I'm going to adjudicate you guilty, sentence you to time served, in court costs are $293, and I'll give you 6 months to pay that, okay?
That's it.
Okay, thank you. Sandra Valent?
Creole interpreter for.
Yes, Judge, Creole interpreter.
Okay.
Just have a seat. We'll call you again, okay?
Petroloni Castro?
All right, Your Honor.
Hi, good morning.
Ms. Castro, good morning. You are being held on a $100 bond on giving a false identification to a law enforcement officer. You're also charged with driving while license suspended and some infractions: child restraint required, failure to wear a seatbelt, and expired tag less than 6 months. Can you make the $100 bond?
Yes, but
Okay.
I don't have my. He had my purse, but he wouldn't give me my purse, so I don't know who to call.
Do you have family that you can call?
Yeah, I have family.
Okay, just call your family, have them set a $100 bond. I'm going to ROR on the driving while license suspended. Okay, ma'am, thank you very much. Tia Mack? North Broward?
How you doing? Good morning, Your Honor.
Good morning, how are you?
I'm fine, but I'm not too fine because I'm here and I'm being accused of something I did not do based on a misunderstanding and a lot of drumming that's going on in my neighborhood, what they got us going through. And I'm being accused, falsely accused, false
Okay.
accusation. I
Listen,
don't want to talk about the case, Your Honor, but I'm sorry, I apologize. We're not in trial, but I
just give
don't
me a
like
chance.
this.
Hello, hello?
Yes, sir. Yes,
Stop
sir.
talking for a moment, okay? No,
Yes, sir.
you can put your arm down. Okay, you're being charged with aggravated battery with a deadly weapon. There is no bond set at the present time. You're also being held on a capious no bond with a status set for 10/21/2018, 2019 at 8:30. And the capious with no bond is before Judge Fine.
Okay, for the for the cocaine, I have no one. Okay, well, Your Honor, Judge Paul, could I please ask you for a favor?
Well, if you're asking me to change the bond on the capious, I can't do that. You have to go in front of Judge
No,
Fine.
I know Judge Paul. He's a very fair, nice judge. He likes me a lot. He'll do that. But Your Honor, Judge Paul, could you please set a bond or pre-trial something for me? Could you please do something in the best interest? For the aggravated battery charge, please. And when I go to court on 21st, I'll do a fine on the case.
State, do you have a recommendation on the ag battery? I'm going to set a $5,000 bond, no contact, on the aggravated battery. And
Thank you so much. It's 5,000, I gotta pay 500. Okay.
okay, thank you.
Thank you so much, Christopher Paul.
Okay.
Okay, what's today's date?
And
Judge, the
what
main
are
jail
these?
has asked for a couple of cases to be called out of turn.
Okay. What are these right here?
When is it? Nelson?
Okay. Oh, I see. Okay.
PC on Miss.
On the
So
ag,
Miss
on the ag
Mack?
battery, yes.
Okay.
And main jail wanted me to call somebody first?
Yes, Judge, actually, there are 4 people they would like you to call out of turn.
Okay.
On page 8, Mr. Belford. They're all at the main jail.
What's the name? Belford. What page, Brian?
8.
I've got it here. It's Nathan Lamar Belford in main jail.
Yes, Judge.
Belford is a medical reset.
Okay?
Next would be Mr. Gordon on page 10.
What's the last name again? Gordon.
Is it Aaron Teague Gordon?
Aaron.
Aaron,
Mr. Gordon, you are charged with exposing sexual organs in public. Your bond is $100. I do find probable cause. Okay?
Is the state in a position to make an offer on this matter?
One moment, Your Honor. Your Honor, state's offered to be an adjudication time served, credit for time served.
Counsel, is there any indication regarding a mental or emotional illness here?
No, not from my perspective, Judge. Thank you.
I would agree to have him placed on probation if he wants to resolve it. And I would want him, I would.
Thank you. No, thank you.
Okay, thank you. The $100 bond. And who is next, sir? Is that it from Maine?
no, we have Mr. Cooper on page 13.
Should be towards the end, right? Here. Got it. Put it in back.
Michael Cooper? Michael Cooper at Maine? Is anybody in Maine? Are you Mr. Cooper?
Yes, Judge.
Mr. Cooper, it looks like you're performing. I don't know if you can hear me, Mr. Cooper, but anyways, you're here before me on, it looks like a count 3, maybe an ad charge. There's apparently count 1 and 2 that are not before me today. You're charged with a petty theft. Your bond is $750, and I do find probable cause. Okay?
Yes, Judge. Mr. Cooper's indicating he just resolved this case to probation. I explained to him that this is an ad charge, I believe, is what the court just indicated on count 3.
Yes.
If this stems from the same incident he just accepted probation for yesterday, is the state willing to offer that on count 3?
Looks like he's on probation for a petty theft. Is there an indication that he resolved the other 2 counts?
You-
He is. What was the sentence in county? Do you know what the
Do we have a release date?
County sentence till November, till January 15th.
Okay, so if he wants to resolve it, plead open to the court, I would adjudicate him guilty and sentence him to 30 days.
That's good.
Willing to accept it, Judge, thank you.
It's a, oh, this is a felony.
Judge, would the court then, at this time, would not be in a position to resolve that matter? Would the court consider placing Mr. Cooper, reducing the bond, RORing him on that count, since he does have a sentence of 180 days mitigated by the SAP program, so he does have a hold, he's not going anywhere. So this way, when he's finished with his county sentence, he'd be able to be released from custody on an ROR on this matter.
Here's
Would
my,
the court consider that?
here's my confusion. It says here in front of me, petty theft. And it says a second degree, so it says a second degree petty theft. It has been filed as a felony? Okay, I'm just going to leave the bond at 750, since he's not going anywhere, and he can go back before the judge that he resolved the other cases.
Thank you, Judge.
Okay. Anybody else at Maine that's out of turn?
One more, Judge, on page 27, Mr. Ballard. Ballard,
Okay, so that's
Chad
near the
Ballard.
end of the docket, right?
very much toward the end, yes.
See, let me ask everybody, is it always like this type of audio?
No,
Is
they
there
just fixed it.
Oh, they fixed it.
Yes, they fixed it.
I hate to have seen it before. Okay, so anyways, Chad Ballard, Mr. Ballard, good morning.
Good morning.
Mr. Ballard, you're here charged with aggravated assault on a law enforcement officer, resisting or obstructing without violence, a DUI, and they say it's your second offense, which increases the penalties, leaving the scene of an accident involving damage and careless driving. Your bond on the DUI is $1,000. I have read the probable cause affidavit. I find probable cause, and I'll hear argument on bond. Defense, what are you looking for? Total, you mean? When you say $7,500 bond, you mean the total when it's added up?
Thank you, Judge. At this time, in speaking, a financial bond at this time is not going to work. Would the court consider for Mr. Ballard pretrial release?
Pretrial, what is your position? Okay. Counsel, I don't know what's going on with the audio, but I cannot hear anything, and especially when you're moving your papers. I guess it's because of the microphone that is right there, but I can't hear anything over here. I don't know what we can do about it. I don't know if they can fix it over there. Anyways, what were you going to say?
Whoever you refer, Your Honor, to pretrial.
Well, have you interviewed this? You don't interview before. It looks like he has an address in Coconut Creek. And state your position is no? I see that his DUI is second offense. When was his first DUI?
2015 at Pinellas County.
Okay.
Your Honor, if he does get put on pretrial, we ask for random testing.
Okay. What I'm going to do, I've read the probable cause affidavit. I'm going to grant the defense motion, ROR on all counts, but to pretrial release. He is to be on level 2 pretrial release with a monitor and a TAD. And he is, of course, not to drive without a valid driver's license. And we'll go from there, okay?
Thank you.
All right, so now we're going back to the regular docket. I see some attorneys here. Mr. Lewis, are you here?
Xavier Feldman, which was
We have that right here.
that was from yesterday.
Yes. Have you seen the additional probable cause affidavit?
I've seen the affidavit. Is this the additional one? Because I think it's the same one from yesterday.
No, it adds the amount, approximately 1,020 grams.
That was different from yesterday.
Yes.
I wasn't here yesterday, Judge. Is Mr. Feldman there somewhere?
Is
he?
Mr. Feldman at Maine?
Should be.
Yes, Judge.
Okay,
There he
there's
is.
Mr. Good morning, Mr. Feldman.
Good morning.
Mr. Lewis is here.
Sorry.
Mr. Lewis is here representing you? Good morning, Judge. James Lewis on behalf of Mr. Feldman. Judge, I see the new affidavit where an amount alleged, that was the issue from yesterday? That there
That
was
is
no
correct.
amount? So, Judge, under the circumstances, I see the bond is set at $500,000. Mr. Feldman is a lifelong resident here, I think has almost no criminal history, if I'm not mistaken. And I think that's a very excessive bond under the circumstances, especially since these testings of fentanyl that have been alleged come back are coming back as to all kinds of things, including things that are not controlled substances. For that, Judge, I'm asking you to reduce the bond to $50,000.
What is the bond on the cocaine?
2,500, Judge.
Okay, and you're asking for 50,000 state's
Yes, Judge,
position?
on count one.
No, Your Honor, given the fact that if Mr. Philbin is convicted, he faces 25 years of Minuteman prison sentence, count one. There is in the circumstances to leave the bond terms. Or,
Does he have any priors?
Your Honor, let me pull it up, I'm sorry. He has a pending felony out of Texas.
Is there a hold on him?
Not that I'm aware of.
So it's just a prior conviction? Do you know what the prior conviction is?
Engaging in organized criminal activity.
Okay,
Some kind of a fraud charge, Judge.
okay. And is he married? Does he have children?
Judge, I don't believe he is married. I believe he does have children. And again, he's lived here his whole life and has almost no, with the exception of that, I think has no criminal history.
All right, what I'm going to do is set a bond of $75,000 on, I guess it's the trafficking in fentanyl, and leave the bond on the cocaine of 20, I think you said 2,500?
2,500 for count two, the cocaine, yes. Judge.
Okay, right. Okay, find probable cause, and it's 75,000.
Thank you, Judge.
Thank you. Any other attorneys that want me to help
Yes,
them?
Your Honor.
Oh, yes, sir.
Mark Douglas for Shamar Nelson. He's printing out on the top of page 28, Your Honor.
Or the forest, oh, here it is. Shamar Nelson?
Yes, Your Honor.
Okay. And there is, when I've reviewed this, it looks like there was a warrant issued by Judge Siegel, so there is probable cause, I find probable cause. Based on the
It
warrant.
appears so, Your Honor. Obviously, having read it, it appears there was some delayed reporting on an allegation of theft and possible robbery here. The information related to the gun and its presence in this activity seems spurious at best, but uncorroborated, that a phone was handed to someone and they just pointed the gun. They didn't see where they pulled the gun from, but they pointed the gun and then drove away. It seems to be tenuous at best. I would ask that the court not find PC on the armed.
Well, I can't, I think it's been found by a circuit court judge as PC, and he's issued the warrant. So PC has already been found.
Well, the court has the ability to render its own opinions on it, so.
Okay, this is on Shamar Nelson. Is he in Maine?
Yes, there's, they didn't hear the name called, so they just called over to.
Sh- Shamar Nelson?
Judge, if we could place him on recall, they're going to get him now.
Okay,
Thank you.
okay, thank you. And Brittany Dugan? Good morning, Ms. Dugan. Mr. Dugan, you being charged with illegal use of a credit card, unlawful possession of an ID, fraudulent use of an ID of another, and you're also being held no bond on a probation violation and no bond on an out-of-county hold. The bonds, you're being held also on a total bond of $2,100, and I find probable cause. Okay? Thank you, ma'am. Clara Jackson?
Good morning.
Good morning, Ms. Jackson. Ms. Jackson, you're being held on a capias pursuant to a probable cause affidavit, and you're being charged with exploitation of the elderly in an amount less than $20,000. And I'll hear argument on bond.
Judge, at this time, the defense is going to request pre-trial release. According to Ms. Jackson, this is the first allegation in her lifetime. She has been here for 30 years. She does work in the medical industry. She has several patients that she needs to get back to take care of. As a result of this being the first allegation in her entire life with the court, consider pre-trial release in lieu of monetary bond.
Let me just understand. She makes her living by treating the elderly at home, right?
At home, in the hospital, everything.
Yes, and in a hospital, Judge.
Yeah, I'm not quite sure I can allow her to go back to that livelihood until this is resolved.
But Judge, that would cause an extreme financial hardship, basically making her homeless if she's not able to support herself and pay the rent, food, etc. Again, it is just an allegation. It's her first offense. You're innocent till proven guilty, so we would ask the court to not do that, because again, the financial hardship it would cause Miss Jackson.
Tell me about Miss Jackson. Is she married?
I'm divorced right now.
Divorced.
And who do you live with?
2 of my children.
And, okay. State, what is your position?
Your Honor, the state will be asking for a $10,000 bond, Your Honor, and no victim contact, as well as no working with the elderly, given the facts of this, of the case.
I don't know if I can order that. That's my question. I know that I can order her no contact with the alleged victim in this case, and not to go to her residence, of course. She has no priors?
Judge, that lady, alleged victim, has passed away.
Because I would.
What were you saying?
She has a battery that was dropped, Your Honor,
Okay.
back in 2005.
All right, what I'm going to do is, can she make any kind of bond at all?
Not with supporting 2 kids on her own now, Judge. No, unfortunately not.
All right, what I'm going to do is release her ROR to pretrial release. She is, of course, not to have any contact with the alleged victim in this offense. My understanding is, according to counsel, that she has passed away. And she is to report every week by phone and once a month in person. We'll go from there, okay? Thank you.
Thank you.
Elza Quintana?
Approaching.
Ms. Quintana, you're charged with grand theft, $10,000 or more, but less than $20,000. Your bond is presently set at $1,000. I've reviewed the probable cause affidavit and find probable cause.
Judge, in speaking with Ms. Quintana, the defense is okay, according to Ms. Quintana, with the bond that's currently set.
Okay, thank you very much. And are there any other attorneys that are waiting for me?
And just an FYI, Judge, the Shamar individual you called before we put on recall, that individual is here.
Okay, we can take Mr. Nelson.
Thank you, sir.
Okay.
Mark Douglas is appearing on his behalf.
Okay. Mr. Nelson, your attorney is here, Mr. Douglas. You are charged with robbery with a firearm. You're being held no bond at the present time. In grand theft, your bond is $5,000. So I'll hear argument on the bond.
Yes, Your Honor, I'm asking the court to review the prior finding of PC that led to the issuance of the warrant, that the allegations are that a phone was handed to Mr. Nelson while he sat in the car. He somehow pulled a gun, which he did not see where he pulled it from, pointed it at her, didn't say anything, and drove away. It sounds tenuous, spurious at best that any gun was in play here. I don't believe there's sufficient corroboration of that gun, and so I would ask the court not to move forward, at least where PC is concerned, on the armed aspect of this charge, so that he could possibly post a bond, and we can have that reviewed.
Yeah, I am finding probable cause. I'll hear argument on the bond.
Mr. Nelson has lived in Broward County, Your Honor, for most of his life. He lives with his parents. He has his grandmother. He's a long-term resident. No prior convictions, and he certainly would present himself to court if he were to be given a bond with the support of his family. And certainly, Your Honor, he's not a flight risk or otherwise a danger to the community. I'd ask the court to set a bond.
Is he married?
He's not married, Your Honor.
And what was the bond that you were asking?
$50,000, Your Honor.
For the PBL, Your Honor?
No, for the robbery.
No, Your Honor. This is a punishable by life offense, Your Honor. The state will be asking for no bond. And it is my understanding, Your Honor, that it is just the court's determination to find PC, and then the judge,
Right.
they would have to do an offer hearing.
I understand. Okay. So I find proof evident, and he'll be held no bond at this time. You have to file your motion for bond reduction before the division judge, okay?
Understood.
Thank you.
Mr. Nelson will be in touch.
And
Judge, the conditions of the warrant, to surrender the passport and preview, are you leaving
well, he's being held no bond right now, so yes, I'm going to leave those, but,
Well, it'll apply to count two.
okay, we'll leave those conditions.
Okay, can you write that on the finding, all conditions?
Lisa's nodding her head yes.
You got it, all conditions remain.
Yes, sir.
Judge, good morning.
Good morning.
Court's permission on page 23 is Jordan Marius. Richard Castillo on behalf of Mr. Marius.
Okay, you'll have to give me a moment to find.
Yes, sir. Yes. Marius.
Gordon Ronald Marius?
Yes, yes, sir.
Okay.
Judge, I'm here to handle the bond matter with the family. I'm just getting a chance to review the probable cause affidavit. So I was asking the court to,
Before you go any further, we need to find Mr. Marius. Is Jordan Marius here at Maine?
He He's at the main jail. He's not in the courtroom. We're bringing him in.
Okay, thank you.
It works out.
You're welcome.
I was gonna ask for it to be placed on a recall so I can talk to the family.
Oh, there you go. Yeah, granted.
Thank you, sir. I'll take that win.
What about Rose Wiggins? Rose Wiggins? That's not Rose Wiggins. I'm just trying to go through order is the best I can. This is Miss Wiggins?
Yes, Judge, Miss Wiggins.
Okay, Miss Wiggins, you're being held on a $15,000 bond for trafficking cocaine, 28 grams or more, but less than 200 grams. You're also being held no bond on 2 violations of probation and/or community control. I do find probable cause. Thank you very much.
Judge, at this time, in speaking with Miss Wiggins, those violations of probation stem from Leon County. So she understands she will, so long as they want her, she'll be extradited to Tallahassee. In the meantime, on count 1, there's a $15,000 bond. And speaking with Miss Wiggins, if the court would consider reducing that to about $5,000, that's something Miss Wiggins believes she would be able to reasonably post once her Leon County matters are resolved.
Well, wouldn't she be held here until the trafficking in cocaine is completed?
It's my understanding, once you're actually released from Broward, whether that's bonding out or whatever the situation may be as far as your release, once you're released in Broward, there's a time that starts ticking for the other counties or state to come get people. That would be a 30-day clock. Otherwise, if you just remain in custody and not released, they can wait till your case is over with to come get you. That's my understanding.
Okay, hold on just for 1 minute. Yes?
That's not the case. Her out-of-county homes are 94806, which is warrantless arrest, so she will remain in Broward.
Okay.
She can't go until these warrants come.
Counsel, I'm going to leave the $15,000 bond at this time. If the violations are resolved, you can go before the division judge on a motion to reduce. Okay? Thank you.
Thank you.
Marietta Greer?
And just FYI, Marius is here as well, Judge.
Okay, he's still outside talking with the family. Thank you.
This is Marietta Greer.
Miss Greer, good morning.
Morning, Judge.
Miss Greer, you're being held on a criminal mischief charge, damages $200. Can anybody hear me? Is there any way that can be repaired or fixed, or why is that? Do you guys put up with this every day? Yes. My God. Has it been brought to anybody's attention? This is the way it is every day? How does Judge Powell? This is terrible. Anyways, on Miss Greer, she's being held to set a bond on a criminal mischief and then throwing a missile into a dwelling, building, or aircraft or a vehicle. I do find probable cause. I'll hear argument on bond.
Judge, at this time, in speaking with Ms. Greer, the defense is going to request pretrial services. A monetary bond for Ms. Greer at this time in her life will not work. She has been living in Broward County 42 years, her entire life. She lives with her brother. She does have a full-time job. She works for Vitas Hospice, as well as also works for Uber. And she's supporting her children. As a result, we're going to ask if the court would consider pretrial release. I've been informed the alleged victim in this matter is not a stranger. This is a dispute between exes.
Okay. And State?
Your Honor, Honor, the state would be asking for a $5,000 bond, no victim contact, and, should I ask for surrender? And any surrender of a weapon, Your Honor, it appears that the victim observed her with a gun.
Okay, here's what I'm going to do. I will ROR to pretrial release. Level 2, with a monitor. She is to have no contact at all in any form or manner with Ernest James Hardy. And she is also to give all weapons that she has in the home to pretrial until this case is resolved. I'm sorry.
Thank you, Judge.
Wait. I'm sorry, she's to turn in the weapons not to pretrial, but to her local police department. Okay, where she lives. Okay, and I do find probable cause.
Again, thank you.
Okay. Willis De Jesus, yes, sir.
Oh, go ahead.
No, I'll take you.
Okay. I have on page 18, Vickery.
Do you know where that is on the docket, kind of?
18?
18.
At the,
Vickery? Victor Vickery?
yes.
Okay, is Mr. Vickery there at Maine? Maine, is Mr. Vickery there? I'm sorry? Oh, they went to get him, okay.
Judge, he's here.
Okay, thank you. Mr. Vickery, good morning. You are here being charged with manslaughter. You're present before the court to set bond. I've read the probable cause affidavit. I'm going to find probable cause, and there is a capias issued by Judge Lynch. And I'll hear argument on bond.
There shouldn't be a capias.
Taylor Hoffman, Your Honor, on behalf of the state, I do agree with him. This offense that he's out on bond for, the sexual battery, did actually occur after the manslaughter, so this wouldn't have violated the
I think
bond.
he's just referring to the capias as far as the arrest warrant, but,
Right here.
right, I know, but it should be, okay, that's what he was taken into custody on, is this capias.
Okay.
Okay, so this offense, or the allegations occurred over a year ago.
What kind of bond are you looking for?
Well, I think it's important that you kind of get the background here, a little bit.
Okay, and I agree with that, but I just want to know at the exception, what is the bond you're looking for?
Your Honor, the state would be,
Not to be vague, but low, but, and I can explain why. That's why I wanted to.
Okay, I'm not getting an answer. What
the
is
state would be
the
asking for $500,000, Your Honor, with pretrial level 1 with a GPS monitor.
$500,000?
Correct.
Now I'd like to respond.
Why is that?
Based on his criminal history, Your Honor, the facts of this case, the fact that he also has a pending punishable by life offense currently for sexual battery.
That is
burglary-
pending?
Yes, Your Honor, pending in front of Judge Lynch for sexual battery, burglary with a battery, as well as a.
Has that bond been revoked?
It is not, Your Honor, 'cause as I said, that offense happened after this one temporarily. This case was pending for a while filing.
Got
Judge,
it.
here's what you need to know, okay? He's been on, first a monitor, then not a monitor, but he's been on pretrial services for over a year now. He shows up to court when is needed. He's not had any failures to appear. He's always in contact with us. He travels routinely out of state for work, comes back to the jurisdiction, contacts pretrial. These allegations predate that. I'm sure you read the probable cause affidavit. This is not your run-of-the-mill manslaughter case. This is not to mention the fact that the credibility of the victim in the sexual battery case has been.
I don't want to hear about the sexual
No.
battery.
It matters because the evidence in this case mostly hinges on her testimony. And so that's an issue for me. So I'm asking for a $100,000 bond and to remain on the same level of pretrial, which he has shown a year's worth of compliance on.
And he's on pretrial on the other sexual battery case?
Correct.
That's what you're talking
Correct.
about?
Level 2,
Okay.
Your Honor.
Okay. I have read the probable cause affidavit. I agree with defense counsel. I am going to set a bond at $100,000. And also, on this case, if he gets out, to be on level 2 pretrial release with a monitor.
Okay, he currently
I know he is.
currently doesn't have a monitor based on the fact that he showed compliance for months and months and months with a monitor. And then he owns a company that he travels for work, which we get permission
I
each time
see.
for. Okay, did they put him back on?
Go ahead. Yeah, it was actually on level 3 monitoring. So I had the monitor, but I was like basically an open
Right,
schedule.
okay. So what we would ask for is the monitor to remain, but him to be able to still give the open schedule. Here's something else you need to know. The victim in the sexual battery case lives in Broward County. He's not allowed in Broward County. He lives in Palm Beach County, stays in Palm Beach County, doesn't come to Broward County. And he's been compliant with that.
The sexual battery case is not before me.
What I'm saying, okay.
What,
What I'm saying is he should be able to remain with the open schedule.
I would agree with that.
Okay, that's all I'm saying.
Okay, so,
Objection, Your Honor.
of course. So my understanding is he's going to be, if he's released, he's on level 2 pretrial release with a monitor with the same conditions as previously on the sexual battery case.
Okay, so that would be an open schedule instead of level 2.
Okay. All right.
Okay, I appreciate it, Judge.
Okay.
Okay. All right, Victor. I'll see you soon, buddy.
Thank you, Judge.
And Willie DeJesus? There you are. Mr. DeJesus, you have a no bond hold on you from out of state. It is from Maryland, okay? Thank you very much.
At this time, unfortunately, I only have a copy of the warrant. Is the court in possession of the probable cause affidavit by any chance?
I am not. I just have the arrest form and the booking report.
Mr. DeJesus is indicating it's not me. I don't know if we can get someone from the not me unit from the state attorney's office to roll his prints.
No, it doesn't work like that for out of state. We have a person that works extradition, they will process this file and contact you. Right now, we have a confirmation hit that it is him, and it's not merely tell us that it's not.
Did you hear that, counsel?
No.
Okay, so it would be handled by extradition. They do have a confirmation that it is him, and they'll work it through extradition, okay?
Thank you.
Thank you. Paul Plunkett? Paul Plunkett? Is this Mr. Plunkett? Mr. Plunkett, you also have an out-of-state hold on you, no bond. It is from Georgia, and it'll be worked through extradition. Thank you.
Thank you, Judge.
Jamar Reyes? Medical reset? Jagdish Nanda? Medical reset? Has the Creole interpreter come in? No. Adam Zayas?
Medical reset, John.
Medical reset? And what about Wendy Jean?
North Brown.
With Broward.
Are you Mr. Jean? Yes?
Yeah.
Okay. Mr. Jean, can you hear me okay?
Yeah.
Okay. Mr. Jean, you're being held no bond on an aggravated battery. Do you have an attorney? Did you hire an attorney? Mr. Reedy, has anybody spoken with him?
Yes, Judge, I've spoken to him.
Is there any concern regarding competency?
Yes, there is, Judge. He also has no bond holds on count 2 and 3. I intend to call his brother after court today.
Okay. So on the ag battery, I'm to set a bond. I'm just going to hold him no bond at this time.
Judge, I'd have to object to that. He is entitled to a bond.
I'm sorry, 10,000? Okay, I'll set it at 10,000. With no victim contact, I don't have a PC here, but anyways, no victim contact. Okay. Martin Molnar?
Conti, Your Honor.
And the audio works at all the other jails.
Judge, we're waiting to find out if we can get a Russian interpreter from Mr. Molnar. This is actually the third day in a row that he's been on our docket, or third time this week.
He does not speak English?
I'm sorry?
He does not speak English?
No, Judge.
I speak English, sir, but I don't understand it so good.
Okay, we're trying to find a Russian interpreter. Your main language is Russian?
Russian and Hungarian.
Okay.
Yes, sir.
Well, do you want to try, Mr. Reedy, if we can?
No, Judge. We went through this yesterday with Judge Powell.
Yeah.
That Mr. Molnar indicated he understood and could continue with his hearing, but it became apparent he did not understand what was going on.
Okay.
So Judge Powell insisted that we have a Russian interpreter present. I'm sure if she was here this morning, she would insist on the same.
Okay, and can we get one this morning, or?
I'm waiting to hear back, Judge.
Okay, we'll put this on recall. I'm supposed to give these back to you, aren't I? Not over there. Sorry about that. Justin Burgess?
Conti again.
Okay, Mr. Burgess, you're being held on a $25 bond for a petty theft. I find probable cause. Can you make the bond, sir?
I'm not sure if I can make. I'm currently in. I took a county sentence, life skills and SAP, to terminate my probation. I don't know if it's possible if you could run it concurrent.
He has 2 no bond holds, Judge, on counts 1 and 2.
Okay, I'm just going to leave the bond at 20. Did you want to resolve this today? Is that what you wanted to do?
Yes. 'Cause I'm already
Yeah,
county
they're
sentenced.
open VOPs, Judge, so he can't resolve it.
Okay. Mr. Burgess, you have some open violations of probation, so we have a concern that you might hurt yourself by resolving this today. I'm just going to leave the bond at $25, okay?
Okay.
Thank you. James Jones?
No problem, John.
To resolve his case.
I'm sorry?
I spoke with him. He wants to resolve his case. Steve planned for.
Okay. So, this is an MO case?
Yes, sir. I talked to him on the phone.
Mr. Jones, you are being held on a capias with a $100 bond
Yes, sir.
for having an open container of alcohol in a public place in the city of Fort Lauderdale, I'm assuming, right?
Yes, sir. Yes, sir.
And my understanding, you wish to resolve it today?
Yes, sir.
Do you understand you're waiving your right to an attorney and a trial?
I'm his attorney. Yeah.
Oh, you are? Have you been appointed?
If you're not, I don't know if you signed the order yet.
I haven't seen an order, but
If you're
anyways,
under appointment.
so I will appoint you as
Thank you, Judge.
as attorney. And you're waiving your right to a trial, sir? Is that what you want to do?
Yes, sir. I'd like to resolve it.
Do you have any questions regarding any rights you're giving up?
No, sir.
Have you had sufficient time to talk with your attorney?
Yes, sir.
And are you pleading no contest to having
Yes, sir.
Just wait for the question.
I'm sorry.
having an open container of alcohol in a public area on October 17, 2019 in the city of Fort Lauderdale in violation of their municipal ordinance?
Yes, sir.
The court's going to accept your plea, find that it's freely and voluntarily given. The court is going to adjudicate you guilty, sentence you to time served, and with court costs of $293, and I'm going to give you a year to pay that, okay?
Yes, sir. Thank you.
Okay, thank you. Henry Davis? Henry Davis? Well, we've seen a lull here where we can't find Mr. Davis. Are you ready? Are there any attorneys ready?
He's here, Judge.
Oh, he's here. Okay, I'll take you right after Mr. Davis, okay? Mr. Davis, you are here charged with trespass and other than in a structure and driving while license suspended. Your bond is $100. And I'll set an ROR on the trespass.
Judge, at this time, is the state in a position to make an offer for Mr. Davis?
If it's an NC, it's a what? I don't have to ROR? What does NC mean? Oh, okay.
Your Honor, the defendant has 893 violations on his DWLL, on his DL record. State, no offer at this time.
Okay, can he make the $100 bond? We don't have his DL record, right?
Judge, he doesn't believe he can make that. Would the court be considered pretrial release?
Right here.
Does he have any history of, oh, thank you. Does he have a history of not showing? I'm just going to ROR him on the second count,
Thank you.
and he'll be noticed. Okay, thank you. Now. Oh, okay, great, thank you. And that would be on, is it Sandra Villant? That's the one? Okay. Sandra Villant?
Sandra Vaillant.
Approaching.
Ms. Villant, good morning.
Ms. Vaillant, bonjour.
Oh, I'm sorry. If you'll raise your right hand, do you swear to translate from Creole to English and English to Creole?
I do. Vivian Saint-Ange, Your Honor.
Ms. St. Ange, thank you for coming.
My pleasure.
And Ms. Villant, you're being held on a $500 bond
Ms. Vaillant, caution ou c'est $500
on a capias
pour yon mandat pour arrestation,
for a petty theft.
pour yon ti vol.
There's an outstanding capias. Probable cause has been found.
Gen yon mandat d'arrestation parce que yo te jwen cause probable.
Can you make that bond, ma'am?
Est-ce que vous ka payer $500?
No.
No.
Judge, is the state in a position to make an offer?
Est-ce que l'État capable faire yon offre pour négocier?
Yes, Your Honor, withhold court costs.
Oui, juge, nou pas condamné, la gen amende frais pour le payer.
Does she want to accept that?
Li vle accepter ça?
So sorry, the offer is?
Withheld in court costs?
One moment, please.
Okay.
Yes, Judge, at this time, Ms. Vaillant would be willing to accept the offer?
Oui, juge, nan moment sa, Ms. Vaillant vle accepter offre sa.
Ms. Valiant, do you swear to tell the truth?
Ms. Vaillant, Ms. Vaillant fait serment pour dire la vérité?
Oui.
Yes.
It's my understanding
Nan sa ke m kompran,
you wish to resolve your case today
ou vle rezoud ka jodi a,
and waive your right to an attorney and to trial. Is that
ou ap
correct?
renonse droit ko genyen pou gen yon avokat e pou ale nan jujman, c'est ça?
Repeat, s'il vous plaît.
Wants to pay, please.
Wants to play? Pay.
Wants to pay, please.
Ms. Vallant,
Miss Vaillant,
listen to me carefully.
koute m avèk prekosyon.
It's my understanding
Nan sa ke m kompran,
that you wish to resolve the case today
ou souwete pou rezoud ka jodi a,
and waive your right to an attorney and a trial.
pou renonse a doa ko genyen pou ale nan jujman.
Is that correct?
Eske se sa?
Oui.
Yes.
Yeah.
Okay. Do you have any questions
Esko genyen kesyon?
as to any
No.
rights you're giving up?
Eske ou gen kesyon pou doa yo ke wap renonse a yo?
No.
No.
And are you pleading no contest
Eske wap deklare ou pap konteste
to the petty theft
pou akuzasyon ti vol?
as charged?
Yes.
The court's going to accept your plea.
Tribunal lan ap aksepte deklarasyon,
I'm going to withhold adjudication.
nou pap kondane ou konya,
That means you are not convicted of the offense,
ki ve dir ko ou pa kondane akuzasyon an,
and you must pay $293 in court costs,
wap genyen fre $293 pou peye,
and I'm going to give you a year to pay that.
ma bo 1 an pou peye.
You can make periodic payments to the clerk of court.
Ou ka peye li pa moso nan sekretarya.
Okay?
Ou kompran?
Merci.
Okay.
Thank you.
Merci.
Thank you.
Thank you, Judge.
All right. And it's Vickery? Maris. Here it is. Okay, Jordan Marius. Is Jordan Marius there? Thank you.
Good morning again, sir. Richard Castillo on behalf of Mr. Maris. Mr. Maris's family and friends are here, and at least one family member wants to address Your Honor on ties to community before I argue for bond, sir.
Let me just ask you before we do that, what is the bond you're looking for?
Roughly $100,000 with any form of pretrial release Your Honor deems fit. My client is 20 years of age. He's a college student with significant ties to community and significant family.
Okay. And State, what are you looking for?
Your Honor, the state will be asking to keep the bonds as is, Your Honor.
Right now it's 1,015,000, 16, 1,700, 8, 9, 10, 11, 12.
Okay.
So that's what you want me to leave it at?
Yes, Your Honor, based on the facts of, I mean, these are very serious charges.
And does he have any priors?
Your Honor, in 2017, he has a reckless driving fleeing an officer, which he was adjudicated to.
And how old is he? He is
20.
20. And he lives here with his family?
Yes, sir. His
And the
parents-
family is all present? Okay. Okay, so here's what I'm going to do. On the trafficking in heroin, 28 grams less than 30, count 2 is 50,000. Count 4 is 50,000. The remaining counts will be $1,000. And if he posts a bond, he is to be released to level 1 pretrial release with a monitor. That is house arrest. And do you I'm sorry?
When you said the rest are remaining, count 3, that first degree felony, you remain at 15,000.
No.
Are you saying the remaining 5 through 11 is $1,000?
Counts 1, 3, 5, 6, 7, 8, 9, 10, 11 would be $1,000 each.
Trafficking cocaine, Your Honor?
Okay, let me go through it again. Everybody looking through the same thing? Okay.
Yes, Judge.
So fleeing and eluding, $1,000. Trafficking in heroin, 28 grams, that's count two, $50,000. Trafficking cocaine, 28 grams less, $1,000. Trafficking, count four, this trafficking, whatever that is, 1B, $50,000. 5, 6, 7, 8, 9, 10, and 11 are all $1,000. If he posts the bond, he is to be on level 1 pretrial release with the monitor, house arrest. Okay?
So would you consider waiving the fee for the monitor, because he's a college student, and they charge, I think, $5 per day? It starts to add up after a while.
Any problem with that pretrial? Okay, I will waive.
Thank you, sir.
And I do find probable cause on the counts, having read the probable cause affidavit. Okay, anything else?
No, sir. Have a good day, sir.
Thank you. Okay. And what about, is it Vickery? No, we did him. What is your client's name?
Thank you, Your Honor. It's Muzamil Javed. I believe it's on page 17. Javed.
It's not here, it's gonna be, that's a violation probation bond. Yeah, it's teaching. There, it goes straight to. It should have went to the DOP.
Right. I think the reason it's not in division, Judge, is that Judge Shear is out at the conference today. So he was arrested about 24 hours ago. I just want to make sure that he doesn't get not magistrated within 48 hours.
On the 21st at 8:30.
Okay.
It's set already. It's 10:21 at 8:30.
When was that set?
Whenever they do the docket, so that's set for the division.
Okay, so he hasn't been magistrated?
No, it should be going down to his regular court. But she's not here, so it's gonna be home to find probable cause. And it's that court. The 21st.
Do I have the documents? Well, I don't know. I'm asking you guys. His name is on the docket? And what is his last name?
Javed.
And where is he located in the,
I believe in Maine.
no, I mean, on the docket so that I can try to find him instead of going through the.
Page 17, Your Honor.
Give me the name one more time.
Sure, last name.
V-E-D. J-A-V-E-D.
Got it. Okay, so he's being held no bond on two outstanding, okay? So there's no reason for me to find probable cause. He's being held on no bond on a violation of probation, 2 counts. I'm not quite sure what you're asking me to do. Well, there's been a warrant filed on both counts, so probable cause has been found. Okay. Right, okay.
And would the
Okay.
court consider reducing his bond at this time?
I can't. You have to go before Judge Shear. It's set no bond.
Right. He's not a VFO, so. Okay. All right,
Okay.
and it's set for Monday. Thank you, Your Honor.
Yes. James Ackland?
It's another municipal ordinance.
Oh, okay. There's Mr. Ackland. It's an open container case?
Yes, sir, he wanted to resolve.
Mr. Ackland, do you swear to tell the truth? You have to turn on the noise machine. Mr. Ackland, do you swear to tell the truth?
Yeah, I do.
Okay, it's my understanding that you wish to resolve your case today and waive your right to both an attorney and a trial. Is that, well, the attorney is here. Waive your right to a trial. Is that correct?
Who?
The guy in the middle, on the bottom?
Oh,
You can resolve with or without an attorney.
Can you see me? Mr. Ackland, can you see? You have to turn on the machine. I can't hear you. Mr. Ackland, can you see me?
yeah, I can.
Okay, it's my understanding that you wish to resolve your case today and waive your right to a trial. Is that correct?
Yes.
All right. Do you have any questions regarding any rights you're giving up today?
Yes, I do. I got one question.
All right.
I was on my way to Walgreens.
Well, don't discuss, sir, don't get into the facts of your case. You can either resolve it or post the bond of $50. You can resolve it with no contest or not.
Mr. Ackland, your bond is $50. You could just post that bond, and we'll set this case for an arraignment. Do you want to do that?
Yeah.
Okay. So,
Thank you, Judge.
I find probable cause, we'll leave the bond at $50. Thank you. Same J. Lamont Knowles. Mr. Knowles, good morning, Mr. Knowles. How are you?
I'm fine, and yourself, sir?
Okay, Mr. Knowles, you are charged with trespassing in a structure unoccupied. Your bond is $25. I've reviewed the probable cause and find probable cause. Can you make the bond, sir?
No, sir, I can't.
Judge, is the state in a position to make an offer at this time?
Does he want to plead open to the court?
Judge, he's asking if time served is an option?
It is.
Yes, sir.
Do you swear to tell the truth?
I do, sir.
And do you understand you're waiving your right to an attorney and a trial?
Yes, sir, I am, sir.
And are you pleading no contest to the charge of trespass at a Walgreens on October 17th, 2019?
Yes, sir, I am.
The court's going to accept your plea, find that it's freely and voluntarily given. The court is going to adjudicate you guilty, sentence you to time served, and court costs $293 with a year to pay. Okay?
Yes, sir, thank you.
Okay, good luck to you.
Likewise.
Juan Antonio Garcia Eubanks.
Speaks English, Your Honor.
Is
I
he
don't
at
know
the
why he's
main?
not coming up.
There he is.
There he is.
What is Mr.
He
Garcia?
said he wanted to resolve.
Okay. Mr. Eubanks, it's my understanding you want to resolve your case today. Is that correct?
Yes, sir.
All right. Do you swear to tell the truth?
Say it again.
Yes, sir.
Okay. And it's my understanding you wish to resolve the case and waive your right to a trial. Is that correct?
Yes, sir.
All right. Do you have any questions regarding any rights you're giving up today?
No, sir.
And are you pleading no contest to the charge of having an open container of alcohol in a public area in the city of Fort Lauderdale?
Yes, sir.
The court's going to accept your plea, find that it's freely and voluntarily given. The court's going to adjudicate you guilty, sentence you to time served. Court costs are $293. Court costs are $50. I'm sorry. Court costs are $50, and I'm going to give him 6 months to pay that. Okay?
Thank you.
Thank you, everyone.
Thank you, sir.
Jonathan Johnson? Mr. Johnson, can you hear me?
Yes, Your Honor.
Okay, Mr. Johnson, you're before the court on a petty theft. You do not have to post a bond on that case, on that charge. You're also charged with possessing drug paraphernalia. The bond is $100. And then there's an outstanding capias for a driving while license suspended, and the judge set the bond at $1,000. Okay? So probable cause has been found? All right.
Judge, due to the fact that it's a traffic criminal case, is the state in a position to make an offer as to all matters?
He has a pending cocaine case out of Palm Beach from just last week.
He has a pending cocaine case in Palm Beach from, I guess, an arrest from last week. Do we have his DO record? What I'm looking at, and maybe you guys can help me, the driving while license suspended was the charge after October 1st, and does he have any priors? Let's see, the capias was issued on August 22nd, 2019, so it has to be before October 1st. So there's not a mandatory 10. But is this going to habitualize him? Oh. We don't have a driving record on him?
No, Your Honor, it seems like CCIS came back with that.
Okay, if he wants to resolve it, what I would do is sentence him to 3 days in Broward County Jail with credit for the time served. I would order court costs, but I must warn him that I do not have his driving record in front of me, and if this is a third driving while license suspended, then it's going to habitualize him.
Judge, Mr. Johnson is aware, and he'd be willing to accept the state's offer.
Well, it's, the state didn't offer, it was the court's offer.
Sorry, the court's offer, thank you.
Okay, Mr. Johnson, you swear to tell the truth?
I do.
It's my understanding you wish to resolve this case today, waive your right to an attorney, and a trial. Is that correct?
Yes, Your Honor.
Okay, so there are two separate cases. You're going to resolve both. Do you understand it?
Yes, Your Honor.
Do you have any questions regarding any rights you're giving up today?
No, Your Honor.
Do you understand that I have no jurisdiction over the Driver's License Bureau? I cannot guarantee or promise you what effect your plea today will have on your driver's license?
Yes, Your Honor.
If it is your third conviction for a driving while license suspended within the last 5 years, your license will be revoked for 5 years as an habitual traffic offender. Do you understand that?
Yes, Your Honor.
Knowing all that, and let's see, are you pleading no contest to a petty theft out of Home Depot and a possession of drug paraphernalia on that same date on 10/17/2019?
Yes, Your Honor.
And are you pleading no contest in case number 19-034926 TC28 to driving while license suspended?
Yes, Your Honor.
The court's going to accept your plea, find that it's freely and voluntarily given. The court is going to adjudicate you guilty on all 3 counts, sentence you to 3 days in the Broward County Jail on count 1 with credit for time served. Court costs $293. Count 2 would be $28. I'm going to give you 6 months to pay that. And on the driving while license suspended, the court costs are $293. Okay?
Yes, Your Honor. Yes, Your Honor. Thank you.
Okay, good luck.
Thank you.
Well, I'm only sentencing him on count 1 to the 3 days, which is the petty theft. Well, count 3 is a different case, right? So I'm adjudicating him guilty, $293 in court costs. Carlos Guerra Gonzalez. Mr. Gonzalez, do you speak English?
Yes, Your Honor.
Okay. Mr. Gonzalez, you're being held on a $100 bond, and you're being charged with misuse of the 911 procedures. I've read the probable cause affidavit. I find probable cause. Can you make the $100 bond?
No, Your Honor.
Is the court in a position to make an offer of time served on this matter?
State? Any problem with that? Okay, yes. Adjudication time served.
Yes, Your Honor.
Okay, do you also swear to tell the truth?
Yes, Your Honor.
And it's my understanding you wish to resolve this case, waive your right to an attorney into trial. Is that correct?
Yes, Your Honor.
Anybody for, okay, and do you have any questions regarding any rights you're giving up today?
No, Your Honor.
And are you pleading no contest to that charge as I just read to you?
Yes, Your Honor.
Court's going to accept your plea, find that it's freely and voluntarily given. The court's going to adjudicate you guilty, sentence you to time served. Court costs are $293, and I'm going to give you 6 months to pay that, okay?
Yes,
Thank you.
Thank you. Willie Calloway? And this must be
It
a
is, Your Honor.
municipal ordinance case,
It is, Your Honor.
and it's possession of a controlled substance with a capias,
Yes, Your Honor.
with a $500 bond.
Yes, Your Honor.
Okay. Mr. Calloway, you're being charged by the city of Fort Lauderdale with possessing cannabis less than 20 grams. Probable cause has already been found, and there's been a capias issued, and the bond set on the capias is $500. Do you understand all that?
Yes, sir.
Can you make the $500 bond?
Yes, sir.
He had indicated he wanted to resolve them.
Do you want to resolve this today?
Yes, sir.
Okay, what I would do, we don't have his driver's license, do we?
Judge, he told me he did not have one. I mean, the offer's usually adjudication withheld, but he does not have a license anyway.
Okay. Mr. Calloway, do you swear to tell the truth?
Yes, sir.
And it's my understanding you wish to resolve the case today and waive your right to a trial. Is that correct?
Yes, sir.
And do you have any questions regarding any rights you're giving up?
Yes, sir.
And are you pleading no contest to possessing cannabis less than 20 grams on October 17th, 2019?
Yes, sir.
Court's going to accept your plea, find that it's freely and voluntarily given. The court is going to withhold adjudication, order court costs of $308, and I'm going to give him 6 months to pay.
Thank you, Judge. Good luck, sir.
Okay?
Thank you.
Thank you. Danny Black? I see that. Okay, so Danny Black has been ROR'd. And Therese Keene? Mr. Keene, you are before the court on an outstanding capias. It looks like an add charge, adding a 5th count of tampering with physical evidence, and that is a felony, and your bond is $1,000. Can you make that bond?
Yeah.
Yeah, okay, thank you, sir. Jake Schellenberger?
Copy, Your Honor.
Mr. Schellenberger, good morning.
Morning.
Oh, that's so much better, isn't it? It's like a breath of fresh air. Anyways, Mr. Schellenberger, and let me ask the state, are these add-ons, okay, to a first count? 8, right. And was there a bond set on that? 1,000? Okay. So, Mr. Schellenberger, apparently you were before the court at a previous time on a grand theft, and your bond was set at $1,000. Since that time, the state has added charges, counts 2 through 8. Count 2 is also another grand theft. Then there's 3 counts of dealing in stolen property, and then 3 counts of giving false information to a pawn shop owner for items $300 or more, and there's 3 counts. Your bond is set on the grand theft at $1,000, and then all the other counts, 3 through 8, are $3,500. I have not totaled that up. I can if you want me to, or at least I can try. But can you make that bond?
No.
Okay.
It would be easier to total up, Judge, if you reduce the bonds on counts 2 through 8 to $1,000 each.
State, any objection to that? Okay, so Mr. Schellenberger, I am going to reduce your bonds on counts 3 through 8, okay, the add-ons, to $1,000 each from $3,500, okay?
Okay.
Okay, thank you, sir. And I do find probable cause. Thank you, Mr. Reedy. Titus Blackman? Titus Blackman? No Titus Blackman anywhere? At the main? I wonder if they can hear me. Okay.
He's coming, Your Honor.
Okay, thank you, sir. Appreciate it very much.
Blackman.
Yes, Mr. Blackman. It looks like that you have already been before the court on counts 1 and 2, and it looks like they've added on counts 3, 4, and 5. In count 3, you're charged with a petty theft, second degree. Your bond is $100, and you're being held no bond on 2 violations of community control on a 2016 case and a 2018 case. Those are before Judge Coleman. And it looks like you're set before the judge Monday at 8:30 on those counts, okay? Thank you very much.
Thank you, Judge.
Thank you.
And good luck, okay?
All right, sir.
Daniel Brown,
Yes, sir.
would they say Conte?
Thank you, sir.
Mr. Brown, good morning, sir.
Good morning.
Mr. Brown, you're being held on it looks like an add-on charge pursuant to a capias in case number 19009835 CF10A. It's a felony. And that is, let me see, it is possession of, what is that state, do you know? What- Possession of substance cathinoids. Okay, apparently it must be a regulated drug. Your bond is $1,000. Are you going to be able to make that?
No, sir. I can't make the other 2 bonds. I can't make. I'm homeless.
Okay. Okay,
That is true.
all right. So I'm just going,
They tried to give me pretrial the first time, but I didn't understand what pretrial was at the moment. Then I get pretrial at the time.
okay, well, your bonds have already been set at $3,500 in counts 1 and 2. This is just an, I understand, this is just an add-on of $1,000. I'm going to leave it at $1,000. You'll be going before the division judge, okay?
How long will that take?
You probably go next week.
All right, sir. Thank you.
Thank you. Tariq Smith? These look like, okay, a lot of add-ons. Probably main jail. Tariq Smith? Yes. Mr. Smith, good morning, sir. Mr. Smith, it also appears that there are 3 counts that are add-ons to 1, 2, 3, and 4 of the same case. They've added count 5, a burglary of an unoccupied conveyance, unarmed, and we're here to set bond. Count 6 is a petty theft of the first degree. They set a bond of $100. And then fraudulent use of a ID of another, your bond is $1,000. So I'll hear argument regarding burglary. Does anybody know the bonds on counts 1 through 4?
Judge, I was made aware from Mr. Smith that counts 1 through 4, if there was a monetary bond, he also was ordered to be on pretrial release through counts 1 through 4. If that actually is the case, the defense is going to simply ask for a pretrial on counts 5, 6, and 7 and negate the need for a monetary bond.
Okay. Okay, so it's 5,000 on each count of the 1, 2, and 3? And then along with pretrial? Okay, so Mr. Smith, right now he has a $5,000 bond on count 1, $2,500 bond on count 2, and a $1,000 bond on count 3. And if he's released, he is on a level 2 pretrial release. So on counts 5, 6, on the burglary on count 5, I'm going to ROR him. And count 6, ROR, and count 7, ROR. He still has the bonds on counts 1, 2, and 3 with pretrial release.
Are you RRing him to pretrial release on this?
Yes.
Level 2?
Level 2, pretrial release on counts 5, 6, and 7. Okay, thank you. Are you waiting for me to sign these? I'm sorry.
It's fine, or I can hold them to me, your call.
No, I'll sign them. I don't want to hold you up. There you go.
Thank you.
Okay, Shakus Davis. This should be Maine. Shakus Davis. Mr. Davis, good morning. You are before the court on a grand theft of a firearm, count 1. Your bond is $1,000. Possession of a weapon or ammunition by a convicted felon, a bond has not been set yet. Carrying a concealed firearm, $1,000. And then you have 5 counts of possession of weapon or ammunition by a convicted felon. I do find probable cause. I think that the 5 counts concern both the gun and the ammunition.
That's correct, Judge, but it's more than 5 counts.
Oh, is there another?
Yeah, it's
Oh, I'm
26
sorry.
counts total.
Thank you very much.
I can say, Judge, generally what we do is the court finds 1 possession of a weapon for the firearm, and sits bond on 1 possession of weapon being for all of the ammunition.
Right.
And then with ROR, Mr. Davis on counts 4 through 26.
Okay, and what kind of bond are you looking for the possession of a weapon by a convicted felon? And what kind of bond is the defense looking for on that count?
He already gave it to you on all the other counts. Judge, would you be willing to do pretrial in lieu of a bond on those remaining counts that he was not ROR'd on? He indicated he hasn't been in trouble in about 10 years or so. He is 44 years of age, does have strong ties here to Broward County his entire life, so he is asking the court for possibility of pretrial.
Well, I am going to make it pretrial, but I'm going to set a bond of $2,500 on count 2, leave the bonds of $1,000 and $1,000 on counts 1 and 3. I'm going to ROR him on the remaining counts, and if he posts bond, he is to be released to pretrial release, level 2 with a monitor. Okay? And he, of course, is not to possess any kind of weapon during the pendency of this case. Okay, Sterling Davis. Sterling Davis. Are you Mr. Davis, sir?
Yes, Your Honor.
Okay, Mr. Davis, you're before the court charged with aggravated assault with a deadly weapon concerning a pair of scissors, and we're here to set bond. I do find probable cause, and you're also charged with a misdemeanor battery. I find probable cause. And you're also before the court on case number 15-004502 TC20A, and that's driving while license suspended, with a bond set by the court of $500. And I'll hear on the ag assault. What's the state looking for? How much? 5? Yes. Okay. And no contact, right?
And no victim contact, correct?
Right, okay. And counsel, what bond are you looking for?
Judge, in speaking with Mr. Davis, financially speaking, if the court would to make that a $2,500 bond on count 1, he does believe he can find the $250 necessary to bond out on that count. Anything exceeding that would be a financial hardship.
Okay, and he would have the 500 on the traffic charge. Okay, so what I will do is I will set a bond of $2,500 on count 1. ROR, well, you just say NC. I'm not going to set a bond on count 2. And then there's the $500 bond on count 3. I'm also going to order pretrial release, standard pretrial release. As a condition of his bond and pretrial release, he's to have no contact in any form or manner with Barbara Vergara. And that'll be it, okay? Thank you.
Thank you, Judge. You got here today.
And Winston Moore? Mr. Moore, good morning, sir. Mr. Moore, you're before the court on 2 counts of, it looks like possessing cocaine with the intent to sell. There's 2 counts. Each count is $2,500. Probable cause has been found by Judge Usan, who issued the warrant and set the amount of the bonds. Okay?
Judge, at this time, would the court consider reducing those bonds? That $50,000 total bond amount would not be reasonable for Mr. Moore at this time. He wanted the court to be aware. He did turn himself in. He does have applications out there, 6 of them he indicated, but in the meantime, he does understand that he would like some help for some treatment, Judge. So he's actually not asking to reduce the bonds at this time. What he's asking for is that the court enter an order to allow him to be placed in the SAP program while in custody, and we'll readdress his bond once he's done with SAP.
That is granted, and Mr. Reedy, could you prepare that order? The bond is going to remain the same, $25,000 in each count, but I'm going to ask Mr. Reedy to prepare an order that the court is requesting that Mr. Moore be entered into the SAP program while he's incarcerated. And
are we keeping all conditions of the warrant?
and all other conditions will remain. Okay, thank you. And Mr. Raymond McLean? Mr. McLean, good morning, sir. Mr. McLean, you're before the court on a trespass charge regarding an automobile. I've read the probable cause affidavit, and I don't find probable cause. Your bond is $25, but you're being held, it looks like, no bond on 2 violations of community control or probation in a 2016 case and a 2017 case. You're scheduled to appear before Judge Weeks this Monday at 8:30, okay? Thank you, sir. Not the PC I read. He said that the car was stopped. He said that the friend gave him a ride and he didn't know the car was stolen, didn't know who the car belonged to. He just was getting a ride. Jamal Stennett? Well, he's going before the, on Monday, before the division judge. Jamal Stennett, is that you, sir? Mr.
I've been indicated he has private attorney, Judge.
Okay, who is your private attorney?
Clement Dean.
Yes, okay.
Judge, I spoke with Mr. Dean earlier, and he indicated he can be here at 1 o'clock this afternoon and is asking the court to reset it for the PM docket.
Okay, we'll keep this here for the PM docket. Thank you, sir. James Hill?
No problem, John.
Mr. Hill, you are before the court charged with aggravated assault with a deadly weapon, and we're here to set bond. I read the probable cause affidavit. I find probable cause, and I'll hear, Mr. Reedy?
Mr. Hill has indicated to me that he's been a resident of Florida all of his life. He's been living in the same location for the last 10 years. And unfortunately, he has a disability that prevents him from working at this time. So he's asking the court to consider possibly pretrial release.
You know, does he live with the victim or the victim's mother?
No, he lives with his girlfriend, Judge.
Well, I think that was the victim, right?
Thought it was his mom.
Let me see if I can figure this out here. It says, made contact with victim 1, she was in a dispute with the defendant. Defendant is currently dating victim 1's mother. The victim is allegedly living at the same address as him, according to the PC. Is there another place that he could live?
Is there another place you can go, James?
Yes,
Where would that be?
that will be with my sister.
Okay, you would have to live there and remain there until it's changed, the change is ordered by the court, and you could have no contact with Miss Pulliam. Do you understand that? Or her mother?
Okay.
Is that any problem for you?
Not really.
No, or not really?
No, it's no problem.
Okay, state, what are you asking for? Okay, so I'm going to release him ROR to a pretrial release with a condition that he has no contact with Shakoria Denise Pulliam or her daughter, and he is not to go within 500 feet of 621 Northwest 13th Terrace. It looks like apartment 1 in Fort Lauderdale. So did you hear that, Mr. Hill? Okay, so no contact means you can't call him, you can't email him, you can't text them, nothing like that, okay?
Okay.
And so you'll be RR'd, then you're gonna have to go to pretrial release, and you were to report once a week by phone and then once a month in person.
Okay.
All right, thank you.
You're welcome, sir.
Marquise Knowles,
I think he's in the main, Judge.
Main Jail.
He's here.
Okay, thank you. Mr. Knowles, you're before the court on burglary with a battery or assault. I think that's a first-degree punishable by life. And you're being held no bond at this time. You're also being charged with throwing a missile into a vehicle or a building. You're being held to set bond, and then you're charged with leaving the scene of a crash involving damage to property, which they've charged as a felony. There is a capias issued by Judge Fine setting no bond. Is he presently set, to anybody's knowledge, to be before Judge Fine on Monday? Okay. So, okay, I'll hear regarding bond.
Thank you, Judge. According to Mr. Knowles, I had the opportunity to speak with him, and this incident stems from a prior ex, and he's now the current boyfriend, so there's some drama there as far as that's concerned. But he did indicate to me that this incident is from a while ago. He believes May that this incident stems from. If that actually is the case, he indicated he's even had court
Yes, I have.
on this matter. He said August 24th, he believed, was the date, which that doesn't really make too much sense to me, because then I don't understand why we'd be here at a bond hearing if he's already had court dates for an arraignment. But with that said, due to the fact that this first-degree felony has a no bond hold on him, I've been told Mr. Knowles has very limited history with the system. There's been no incidents between these two individuals since this incident occurred. As a result, we're going to ask if the court would consider pre-trial release for Mr. Knowles, because he is a father. I'm sorry, not a father. He wants to continue to work and maintain his job.
Well, this is a first-degree punishable by life. Isn't that a no bond if I find proof is evident?
Yes, Judge, but even you can still issue a bond, even making that finding.
Okay, I'm going to find proof is evident. I'm going to hold him no bond. He'll have to go before Judge Fine. Okay?
That would be over our objection, Judge.
Okay. What is
Thank
your,
you.
Mr. Reedy, what's the objection? What is,
Our objection is that proof evident presumption grade is the highest standard of proof that we have
okay, got it.
in the criminal justice system.
Oh, yes, correct. So no bond on count one. On count two will be a $5,000 bond. I'm going to leave the $25 bond on leaving the scene. And as a condition of the bond, no victim contact. And, yes, okay. That's blocked out. All right.
So
Thank
sorry,
you.
sorry to interrupt, Judge.
Sure.
Because it doesn't say it on the docket, does Mr. Knowles have court with Mr. Judge Fine on Monday?
It doesn't say.
Okay.
It doesn't indicate.
That's okay. I'll make some phone calls on my lunch to make sure if it's not said, it is said.
Okay,
Thank
very
you.
good. Thank you. Marlon Phillips?
No problem, John.
Mr. Phillips, good morning, sir.
Good morning, Your Honor.
Mr. Phillips, you're charged before the court with petty theft, the second degree, but it looks like it's going to be charged as a felony. And the bond is $750. And you're also charged with resisting or obstructing without violence, which is a misdemeanor. And you don't have to post a bond on that charge. Can you make the $750?
No, Your Honor.
Do you have any family or friends that will post it for you?
Okay, I'll keep you posted.
I doubt it.
Okay.
Judge, would the court consider an ROR from Mr. Phillips?
State any objection? Mr. Phillips, do you have a place to live?
At the time, I'm actually going to an address in Coconut Creek.
Okay, the address on the booking sheet? Okay. What I'm going to do is ROR you to pretrial release, standard pretrial release. You're to report by telephone once a week and in person once every month, okay?
Yes, sir.
Okay, thank you, sir.
Thank you. Judge Paul.
Yes, sir.
Judge Paul.
Yes, sir.
Louis Brown is requesting that you take one out of turn, please. He's the second to the last name on the docket, Grayhart.
Christopher Grayhart, I have it right here.
Thank you, sir.
His mother is here, Judge, and she was here yesterday as well.
Okay. Miss Grayhart?
Yes, sir.
Good morning, sir.
How you doing, sir?
Good, good, thank you. Mr. Grayhart, your mom's here, and
Yes, sir.
I have read the probable cause affidavit. You are charged with filing a false report regarding a bomb.
Can I talk, sir?
No, sir, not yet. Just give me a minute, okay?
Yes.
And what did you want to say to the court?
I want
No,
to
no,
say,
no,
sir.
no, sir. I'm talking to your mom. I'm talking to your mother.
Chris,
Let mama talk.
Mr. Grayhart, listen for a moment, okay? Just listen. Yes, ma'am.
I'm here on behalf of my son Christopher today. I'm very disappointed with Florida Medical Center. He was doing good. He got out on RR. He was in a program. I bailed him out on his first charge because he was getting mistreated in jail a little bit, and I got him out so he can get the proper help he needs.
What kind of help is he getting?
He's not getting, he been in the system a long time. I done went in front of every judge. They not giving him the mental help he need. He had mental problems ever since he been a little boy. So I've been trying to get him help, but no judges don't want to listen to me.
Okay,
So it should have never boiled down to this.
okay.
So I
Does
put
he
him
live with you?
No, he's not living with me. I put him somewhere where he can get some help. I'm working on getting a place soon. So
Where does he live?
he was living in Chris, let mama talk. He was living in a sober house. And when he got out, he come there. I paid them. They put him out the next day because he was complaining about they had him on the sofa. So when they put him out, the guy who I'm renting from, he don't want Christopher there because he don't like Christopher, and so he was like, we don't get along. So I said, no problem. So I took him to the motel. He got abused again, and I took him to the hospital.
When you say you took him to the hotel, are you living in a hotel?
No, I took him there because I had some money. I put him up in a room in a motel. So when I put him up there, I said, Chris, you're not acting right. So I took him to the hospital. He wanted to go. So when I took him to the hospital, they took him in. So I called to check up on him.
Okay, ma'am, just give me 1 second. Mr. Reedy, have you talked with her or Mr. Grayhart? Do you have a recommendation?
Briefly, Judge, I did not get much of an opportunity to speak to him He directed me to speak to his mother.
Okay.
And I spoke with her yesterday as well as this morning, and
What is your recommendation here as far as,
Your Honor?
yes?
He's currently on pretrial in case number 19009335MM10A for resist obstruct without violence. Pretrial is asking that you revoke his pretrial.
It was already revoked. I went to the judge and told the judge he needs some help. So
You don't have a warrant showing him yet.
Excuse me, sir.
I went to the judge and begged for him to have a pickup order, so they already was in the making.
Okay,
I let the hospital know.
everybody, just give me 1 second. Mr. Reedy, I'm sorry for the interruption.
no, it's all right. I was just double checking the statute. I think that last year they added firearms to it. Says there's no indication here that, I don't know that there's probable cause, actually.
Either do I. I question it myself.
What happened when I went to the
Hold on,
hospital?
ma'am.
Yes.
But what I'm,
Ma, let him talk, Ma. Let him talk.
but what I'm,
I mean,
If-
I would make the argument that there's no probable cause here.
and I would tend to agree with you, but I'm going to listen to the state. But my question to everybody is, if I release him, where's he going to go?
Well,
Okay, can I say something?
Yes,
a
ma'am.
caseworker came. The hospital told me that he was doing good. A caseworker came in to see him the same day, and she said, "Chris will be getting you ready for a room." Okay. All of a sudden, Chris said he was laying in the bed. They came in there and tried to inject him. Chris said, "No, I only take that when I'm not doing good." Then he said the police have sprayed mace all in his face and everything.
Ma'am, listen to me for a moment, okay? You've got to get a hold of yourself.
It's
Listen
just
to
that when
me.
mental people get treated so
Listen
bad.
to me. Right now, we're just here to determine.
Okay.
If he was to walk out of the door from the jailhouse right now, where would he go?
What I'm consistent is that I get in touch with the his caseworker. She was in the making of getting him a place. Okay. I want to work on getting him in a place. They already had it going. She told me to call her to let her know what's going to happen in court. Okay.
The caseworker from where?
He got a caseworker over the she just over him because he go to IMO, a program every day.
Here's my question that I'm trying to figure out. Where would he live if he was released?
Okay, that's the problem. He was supposed to go from the hospital to the program.
This is a felony, right?
Yes, Judge.
And if I transferred it to Judge, I'm sorry? You can't transfer felony.
Our office usually screens.
I got another.
Wait a
Hold on,
minute,
ma'am.
wait a minute.
Okay.
I'm sorry.
Usually my supervisor screens and notifies them to hold court of people that appeared in first appearance that are eligible.
I think that if we could get him before the judge on Monday morning, what's his name? Ari Porth, Judge Porth, if we could get him before Judge Porth, they may know and have the expertise as far as how to place him and what to do, and
Yeah,
that's what I would like to do.
let's get him the
I
help.
don't
he
want to
needs.
just release him onto the street with his situation.
Yes.
So, I'm gonna, order. Well, I've got to set a bond, right? And the question is, State, what is your position regarding probable cause on this?
Your Honor, it's the state's position that there is probable cause. Looking at the statute, it states that any person who makes a threat concerning the use of firearms in a violent manner against a person or person, Your Honor, it seems that per the PC, the defendant said that he would track down the victim's family and shoot him. It's
Sir, all that was said when he first got in there.
Don't say anything
Okay,
else, please.
so-
Okay.
So I am gonna find probable cause.
All right.
Yeah, because he wasn't in the state.
No.
What I'm going to do is set a $10,000 bond, but I would like to get this case before Judge Porth on Monday morning. Is there any way we can do that? set before Judge Porth on? Lisa? Is there any way we could get this set before Judge Porth on Monday morning? I knew I could count on her.
Thank
Okay, so that's what I'm going to do, and hopefully he'll be able to help your son, okay?
All right, thanks a lot.
Thank you, ma'am.
Bye,
Your Honor, are you revoking his pretrial?
Well, this is in front of whom?
That's in front of Judge Gottlieb.
Is that this case?
No, the resist obstruct is the top charge to the top right. The resist obstruct is the charge that he's on pretrial for.
I am not going to
Okay.
revoke it, okay? Thank you.
you.
Okay, Andrew Creel? Andrew Creel? Good morning, Mr. Creel, how are you? Mr. Creel, you're before the court charged with burglary of an unoccupied conveyance, unarmed. We're here to set bond. You're also charged with 3 counts of possessing, received, or retained stolen credit cards. Your bonds on each of those 3 counts are $1,000. You're charged with avoiding or attempting to avoid payment on a phone under $300. It's $1,000. Fraudulent use of possession of an ID, another $1,000. And then possession of drug paraphernalia, your bond is $100. I've reviewed the probable cause affidavit and find probable cause. Can you make that bond, sir?
Not right now. No, Judge, at this time, unfortunately, Mr. Creel is homeless. He has been in Broward his entire life, 27 years. What he's asking this court to do while his case is pending, if the court would enter an order to allow him to be placed on the list for the SAP program.
And that is granted. So I'm going to leave the bonds as is, and I will sign the order. Mr. Reedy will.
With regards to count 1, we would need to set a
Oh,
bond.
we have to set a bond on the burglary. Thank you very much. Okay, what I'm going to do is set a bond of $2,500 on count 1. And I will sign that order for SAP. Okay? Thank you. Olawaku Deloju. Good morning, sir. Sir, you're in front of the court charged with possession of cocaine and third-degree felony. Bond is $1,000. I find probable cause. You also have an outstanding capias signed by Judge Porth in 19-006-775 CF10A, and he set a no bond on that count, okay? So you'll be going before Judge Porth on October 21st, which is Monday at 8:30. Okay? Thank you, sir.
Judge, if I could very quickly interject, in speaking with Mr. Adelaje, he's very confused because he indicated he took a proactive step and kept calling the clerk's office multiple times over a period of time to find out when his court date was. As a result of that, can the court confirm that he actually was given notice on the day the capias was issued? Because, again, he indicated he had no knowledge of the court date.
Well, I think that he could take that up with Judge Porth, who issued the
court date
capias
was?
on Monday.
No. This past Monday that just passed?
No. What I said is he can take that issue up with Judge Porth when he appears before him on Monday at 8:30. Okay?
Thank you.
Thank you. Michael Stedman?
Yes, sir.
Judge, we believe, here's a copy of the second page, because this was the original. I don't know if you have that attached to your paperwork.
I do not.
That should be the rest of it.
Yes, I wrote on here, no report. Okay, so thank you. Okay, Mr. Stedman,
Yes, sir.
where are you?
Right here.
Gotcha, okay. All right. Mr. Stedman, if you'll give me a moment.
Yes, sir.
You are charged with driving while license suspended. They've charged it as a felony because they're alleging it's your third or subsequent offense. You're charged with grand theft auto and charged with possession of drug paraphernalia. Your total bond is $1,850. But give me 1 second.
Yes, sir.
Okay, so I've read the probable cause affidavit. I find probable cause. Can you make those bonds, sir?
No, sir.
No, he cannot, Judge, unfortunately. He has been a resident here for the last 55 years. Unfortunately, right now, the only place he could go is to a facility in Dade County, sort of a group home type of drug rehab place. So I'd ask the court to consider pretrial release because he's never going to be able to make a monetary bond.
Is he homeless at the present time?
Yes, he is, Judge.
Okay. State your position. Mr. Sedman, it's my understanding financially you can't make any kind of monetary bond at all. Is that correct?
Yes, sir. Yes, sir.
Okay. And if you were released, where would you go?
Well, I plan on going to the Miami Rescue Mission.
Okay. Would you have access to a phone?
I have a phone in my property, but it's not on at the minute. It's a government phone, food stamp phone. My minutes
Okay.
ran out of it.
But I mean, if you were released, would you have the ability to call into pretrial release?
Yes, sir, I will.
Okay, so I find probable cause. I'm going to ROR him on all 3 counts, but to standard pretrial release. He is to report by phone once a week. Mr. Stedman, I want you to report to pretrial release once a week by phone and then once a month in person. Are you going to be able to get transportation to pretrial release?
I think I'll be able to, sir.
Okay. All right, thank you, everybody.
Thank you.
Thank you, sir. Myron Kellerman Mines. Probably at Maine. Yes. Are you Mr. Kellerman Mines?
Yes, sir.
Okay, Mr. Mines, you are before the court charged with petty theft, and your bond is $25. You're also being held no bond on a probation violation from Judge Porth. You are to appear before Judge Porth Monday at 8:30. Okay? Thank you very much.
Judge, Mr. Kalaman is asking the court, and it is against the advice of defense counsel, if the court or the state would be willing to make an offer on count 1, the petty theft matter. I did indicate to Mr. Kalaman that could be the basis to violate his probation, his admission to that charge, but he still wants to ask the court or state for an offer on that count.
Mr. Mines, what your attorney is telling you is exactly correct. And he's advising you to wait till Monday morning to go before the judge. You might be able to resolve all of it. You don't want to do that?
Can I, even if I do resolve it on Monday, I still violate probation, right?
Well, you're going before the judge Monday on that violation of probation, and you would be able to determine whether this petty theft is one of the alleged offenses for the violation of probation. I suggest to you that you listen to your attorney. He knows what he's talking about. He knows what he's doing. and take his advice. I couldn't hear him. Go ahead.
Yes, sir. I will listen to my attorney.
Okay. Thank you, sir.
Thank you, judges.
All right. And I signed this on Grayhart? Okay. Gabriel Cubano? Mr. Cubano, you're before the court charged with grand theft. Your bond is $1,000, and count two, you're charged with dealing in stolen property. Your bond is $3,500. I do find probable cause, having read the probable cause affidavit. I'll hear argument regarding bond.
I'm sorry, Judge, what page are we on?
This is
24.
Gabriel,
Thank you.
Gabriel Cubano.
Judge, at this time, I did have the opportunity to speak with Mr. Cubano. The $4,500 total bond that's set on this matter is not something he's able to financially post. Would the court consider pretrial services? He did indicate he does have a valid address.
Any objection, State? Mr. Cubano, are you on probation in Miami?
I was.
Do you know, is there a violation pending?
He indicates no, he believes he's no longer on probation. He believes he was on probation.
Got it, okay. I've read the probable cause affidavit. I have no problem putting him on pretrial release and having him report. So, Mr. Cubano, I'm going to ROR you on both counts to pretrial release, standard pretrial release. Do you live in Broward County?
Yes, sir.
Okay, so you're to report once a week by phone and twice a month in person, okay?
Yes, sir.
All right.
Thank you.
Thank you. Leroy Williams?
Present.
Mr. Williams, you are charged with multiple counts here. Trafficking in cocaine, use of a two-way communication device to facilitate a felony, possession of drug paraphernalia, distributing heroin. There's a total of 18 counts. The 19th count is you're being held no bond on a violation of probation. You're set to appear before Judge Shearer on October 21st at 8:30, okay? Do you understand?
Yes, sir.
Okay, thank you, sir.
Thank you.
Jorge Zapata? Mr. Zapata, good morning, sir. You are charged with dealing in stolen property. I've read the probable cause affidavit, find probable cause. Your bond is presently set at $3,500.
That's fine with the defense. Thank you, Judge.
Thank you. Ossie Mounts? Mr. Mounts, good morning, sir. You are charged with driving while license suspended. They're alleging this is your third offense. Your bond is $750, and you're also charged with an expired tag less than 6 months, which would be a civil infraction. So your bond is a total of $750. Can you make that? Counsel, there you go. Thank you. Can you
I'm
make,
sorry.
can you make the $750 bond?
Yes, sir.
Okay,
But
thank you. Thank you.
I was asking, I don't know why my license is suspended. Cause I just had a job
Okay,
doing,
no.
driving.
Listen to me. Don't talk about the case. When you go before the court, they'll explain everything to you, okay? You'll be sent for an arraignment.
Judge, would the court consider an ROR on this traffic matter in lieu of monetary bond?
I didn't do it.
He indicated he's been on pretrial before and he had no violations as a result.
Well, he's looking at a mandatory minimum of 7 days, or 10 days in the Broward County Jail if he's convicted of this offense, based on what I'm reading here. State, do you have any objection to standard pretrial? Okay, so I will ROR him on count one, the driving while license suspended, but he's going to be ROR to standard pretrial release. He is to report by phone once a week and in person once a month.
Thank you, sir.
Thank you.
Okay. John Diaz?
Your Honor.
Conte?
Wheelchair. Just pull up so I can back out.
Good morning, Mr. Diaz. I can see you.
Okay.
You're all right.
Thank you, sir.
I can, anyways, you are charged with aggravated battery with a deadly weapon. Probable cause has already been found, and Judge Fine has issued a capias setting no bond.
Yes, sir.
It was a change of charge from what?
Aggravated battery.
Oh, I see. So initially it was aggravated battery, now it's aggravated battery with a deadly weapon.
Yes, sir. A butter knife, sir.
Okay.
Don't discuss the facts of the
The
case.
bond was $5,000? I'm just going to leave the bond at $5,000, sir.
Thank you, sir.
Thank you. Sir, Mr. Diaz, also as a condition of your bond, you can have no contact with the alleged victim. Do you understand that? Okay, thank you. Travis McCree?
Paul Ryan, Your Honor.
Yes, Your Honor, Mr. McCree has private counsel. I've spoken with his attorney, Larry Besser. Mr. Besser is currently in court in Dade County. Says he can be here close to 1 o'clock for this, if we reset this for this afternoon.
Not a problem at all. We'll hear it this afternoon. And lastly, I think, is Javier Mejia Rowe? Okay, so that has been removed from the docket. I'll hand this to Lisa. And I've got one over here, Martin Molnar.
That's the one for the Russian.
The Russian interpreter will be here at 1 o'clock.
Very good. We'll keep that at 1 o'clock. And as far as I can see, we're completed for this morning. Am I correct?
There is a
Judge,
24-hour...
if I may interject briefly on a brief recall of one of the individuals just recently called, Leroy Williams, trafficking in cocaine. Could we please enter an order that while in custody, the client is permitted to enter the SAP program?
I have no objection to that at all.
Thank you.
Okay? These are yours.
Thank you.
And let me see, we keep that there.
We do have one 24-hour perfection from yesterday.
Is that Belford?
Feldman. Oh, is that the one that had private counsel? Xavier Feldman. Okay,
Oh.
okay.
Lisa, this is, you gave me this morning, and I had,
Then we are done.
I have Nathaniel Belford here on order of pretrial release, so that, okay. And that, this I think is yours.
Oh, that doesn't belong to me. I saw that sitting up here. That's why I passed it along. I think it goes to the clerk.
On Nathaniel Belford?
He was a reset.
For tomorrow?
I believe. It was a medical reset for tomorrow, yes.
Okay, so this I can just throw away right now.
I think you can pass it to the clerk and they'll dispose of it.
Okay. A clarification on. Okay.
Of them, if you remember. You are the rest of them, because he had quite a few, right? But you set a bond for at least one of them, and it looks like you crossed out.
No, on all of these possessions of weapon by ammo or.
6 was RR.
ROR.
But count 2, you set a $2,500 bond, and you have RR.
I wrote that?
Yeah.
No, I didn't write that. Lisa wrote that. I just signed it.
Count
No,
1.
I think I left count 1 1,000, count 3 1,000, and I put 2,500 on the.
Count 2, right, and then 4 through 26 was RR.
Right.
But it looks like on here, she put RR on count 2, that should be 2,500.
Lisa?
They killing me.
Okay, and I signed this, the order, for Mr. Reedy. All right, and we're off system.
Yes, Conti, Your Honor, we do have, Mr. Molnar.
Reset for afternoon.
It's reset for this.
My fault, Deputy. We got the Russian interpreter coming in at 1 o'clock.
Thank you, sir.
Okay, sorry, I should have told you. My
No problem.
apologies.